Okay. Very good evening, everyone. Good evening, students. So, first of all, I welcome each one of you to my class on the proclaimed offender. Let's start with my brief introduction first. My name is Sandeep Khatri, and these are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask your questions in relation to your judicial preparation. At last, I have mentioned my code that is Khatri10, which you can use to get free access of all the special classes available on Unacademy and also to get 10% discount for all the plus courses. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So before starting the session, if you have any questions in your mind in relation to the previous classes, you may ask. And if not, then you can quickly give me a thumbs up. I'll straight away start with the session. Yes, anything, any questions? Okay, I have not received any question, so I'm straight away starting with the topic. So students, as you know, with the heading of this video, that our topic is proclaimed offender. So let's begin with the simple introduction. So students, story starts with that what if, when there is Mr. A, he has committed an offense. And he has committed an offense against Mr. P. Now the thing is, A will be play the role of accused. And once, because he is, as of now, we term him as an accused, we need his presence in the court. Now the question is how this person can be in this court. So first the court will use either summons and then, if possible, then the warrant. If after, giving summons or even after warrant, if the person is not available, then we will go to section number 82 of CRPC, that is basically proclaimed offender. Now, one more important thing here, students. The very first question is whether whether warrant is a prerequisite for section 82. Yes, anyone who likes to answer this question, whether warrant is a prerequisite for the concept of proclaimed offender, or even in the cases, even without warrant, you can proclaim someone as a proclaimed offender. So what is going to be the answer? Yes, anyone who likes to answer in the comments. Okay. Now let me give you the answer, students. When it comes to proclaimed offender, warrant is one of the prerequisite. So basically, without warrant, you cannot initiate the process of proclaimed offender. Now coming to the basics of section number 82. So what are the essentials of section number 82? So the proclamation that the person is absconding, this will start by whom? The answer is court. Who can give the proclamation? The answer lies in court. It is not the job of police or anyone else. Second one, in what cases the court will issue a proclamation? So when the court has reason to believe. Now what is reason to believe? So this term has been defined in IPC. So that is basically your section number 26, that what is a reason to believe when you have some reasons to believe on a certain fact. Okay. So when the court has reason to believe against whom warrant has been issued, against whom that warrant has been issued, and that person has absconded. So basically, when the court has some reason to believe that the warrant that has been already been issued, that is not going to be executed, and the person has absconded, then it is the discretion of the court. It is the discretion of the court that the court may publish a written proclamation. And this proclamation will require that person to be present in the court at a specific time, at a specific location. But that should not be not less than 30 days. And when these 30 days will start? From the start of the pasting of that written proclamation. Those 30 days will start. So basically, this is your section number 82, clause 1, where the court has some reason to believe that the warrant that has been issued. So basically, through this point, you can say that it is a prerequisite. Without warrant, if the warrant has not been issued, then section 82 cannot come into the picture. So warrant is basically, you can say, one of the most important essential for proclaimed offender. So it's a prerequisite. And the person has been absconded. Now in that circumstances, the court has to given a written proclamation not less than 30 days. Any question from this chart? Yes, please. Okay, now coming to the clause number 2, the proclamation shall be published as follows. It shall be publicly read in some conspicuous place. Now, what do you mean by this term conspicuous place? So, this is basically we are talking about a place where it can be easily read by the person for whom this has been pasted. So it is usually, you can say, the door of the house, the basically the main entrance of the house. Okay, so that is what we say, the conspicuous place of the it shall be publicly read in some conspicuous place of the town or village in which such person ordinary resides. Okay, so you can say basically that some examples of the chopal. Okay, it shall be affixed to some conspicuous part of the house, which I just told you, that the door of the house, okay, the main entrance, or homestead in which such person ordinarily resides. So ordinarily resides here means where he usually resides. It must not be any hotel or some place of a friend where he was for some temporary period. So it shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides, or to some conspicuous place of such town or village. Okay, if there was no permanent residence, okay, there may be circumstances that one person has no permanent place to live with. In that case, then we will paste it at any conspicuous place of such town or village. So basically, one of the example can be the chopal, okay, where usually people sit together. The third one is a copy thereof shall be affixed to some conspicuous part of the courthouse, which means the same copy of that proclamation must be affixed in the courthouse as well. The court may also, if things fit, direct a copy of the proclamation to be published in a daily newspaper. Now the thing is, why do we need, why we are including this, the concept of the newspaper here? The reasons are again very, very simple. So basically the court, with the help of section 82, is basically trying that how we can reach to the person for whom that proclamation has been made. So all the efforts that are we are making, it is basically because of the natural justice. As you all must have heard about this famous maxim, that is odi altum partem. Now, in short, see, there can be two easily circumstances. Okay, let me give you one detailed example on this. See, there can be two circumstances. One is intentionally absconding, which means the person knows that the court is looking for that person. Okay, the person knows this, so he is intentionally hiding. Now, why he is intentionally hiding? Because he knows that if the court will not get to know about this, that the summons or the warrant has not been reached to me, then I'm not liable to, present in the court of law. And the second one is the genuine cases. In these genuine cases, basically, the court, there are such circumstances that the summons were not being affected, the warrant has not been affected. So there may be some genuine reasons as well. So to make this, make this person available to the court, so that is why we are making that information in the newspaper as well, so that that person at least got to know about this. So once the news is out in a local newspaper, all the persons of that town knows ki so and so person, the court is looking for that person. Okay, and still if that person is not known, then he cannot take that defense much later. Okay, so these are the reasoning behind this concept. Very good evening, Shivangi. Any questions? Yes, please. Yes, I'm looking for your questions, queries. Okay, now coming to the next and the last topic of section number 82, that is basically the conclusive proof. Now, see, there are three kinds of presumptions. The first one is the court may presume. The second one is your shall presume. And the final one is your conclusive proof. Now, first, let's understand the meaning, and after that, I'll connect this topic with the section number 82. Everyone, please be attentive. This is important. When it comes to these three presumptions, they are basically under section number 4 of Indian Evidence Act. Okay. Now, the very first question is, sir, why do we need the concept of presumptions? Why there is need of presumptions? So the answer to that question is, uh, there are circumstances when the court don't know about the facts, that what are the real facts, and if in these circumstances there needs to be burden of proof on one party. So for example, in the cases of if the court may presume certain fact, now one party, the other party, the party who wants that the court must not presume these facts, the burden of proof is on that party. So if when we say it is a case of may presume, which means it is rebuttable as well. You may rebut that. The other party, whosoever the party don't want the court to presume that. Court shall presume. Now, what is the major difference between may presume and shall presume? In this, the first category, the court has all the discretions, whether they want to presume this or not. But in case of shall presume, the court has to compulsorily presume that. But again, even in these circumstances, it is something which is rebuttable. So the party may change that with the help of producing evidences in the court of law. Now, coming to the last part, that is the conclusive proof, which means if there are certain conditions that has been fulfilled, then the court will conclusively that has been proved, which means the court will, court, this is something which is irrebuttable also, which means the court will not take any evidences as well. Now the thing is, sir, how this concept is related to section number 82. So once summons has been out, once warrant has been out, but they has not been affected, after that proclamation has been out, okay, then there is news in the newspaper as well. There may be circumstances that the person against whom all this has taken place, that person has still no idea about this. But even if in under this case, if the facts are such, this is going to be conclusive proof. This newspaper thing is going to be treated as a conclusive proof that as far as the duty of the court is concerned, we are done with this. We have already given you the information. We have done the best which we could have done. So in short, it will be presumed that the person has already known this, and he will not be, even given opportunity to give evidence that he had no idea about the proclamation or the warrant and so on. So this is going to be treated as a conclusive proof, which is something is irrebuttable. Any questions from this part? Yes, please. Yes, Shivangi, any questions? Okay. So that was the topic. Yes, students, any questions? Anything which is not clear to you? Okay. So this is the link of my profile, my Telegram channel, and this is my code Khatri10. So let's crack PCS J with Unacademy revamped test series. This is the revamped test series for judiciary learners, and we have a special offering this December, as you can see on the screen, the prelims and the mains examination. This is the Bihar State Judiciary batch. This is the Judiciary Legends UP batch. This is what you can see of the plus and the iconic price after the referral code. This is the Articulate, which is a coming soon monthly current affair magazine. These are the YouTube channels of Unacademy. These are the Telegram channels of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.